and make it very clear. It was also addressed during our meetings, with the series of meetings that occurred thereafter. This issue was addressed. It got to a stage, what had then happened was that we went, and I'll be very specific. On the 3rd of June, there was a meeting. On the 4th of June, the General Mkwanazi, at a meeting that we had with myself and my office, he did raise this issue.
Advocate Harrison, which year?
2019, Chairperson, 2019. So this memorandum, this correspondence is received from the National Director of Public Prosecutions. There are a series of meetings that take place. On the 4th of June, General Mkwanazi, in a meeting, he spoke about these questionable withdrawals by the NPA and decisions. What then the team and I went and did is that we requested for a list of dockets where they were concerned in, so that we could review the decisions that had been made by the prosecutors. Indeed, Chairperson, this was done. And we found that, in fact, the decisions that had been made by the prosecutors, they were justified under the circumstances. But what I do want to explain is that it was not only that, it actually led to some drastic step in that dockets had been opened against certain of the prosecutors regarding some of the decisions that had been made. Again, the process was followed of reviewing those dockets. And what we would do then is that we got the mother dockets, we got the dockets that had been opened against the prosecutors. We viewed these in conjunction, so you'll have to read the mother docket to determine and then look at the defeating. And in all of those, the decisions by the prosecutors were justified. Maybe it's the manner in which they had dealt with the matter that made the PKTT not happy regarding that and then had opened dockets. Thank you.
What would that manner be? If the decisions themselves were justified, what would the manner be?
If the decision were fine, let me put it this way, Commissioner, what really should have happened is that they should have requested for a review of the prosecutorial decisions, what is often the process, rather than opening up the criminal cases against the prosecutors. And like one of them was the prosecutor had referred, I think, the matter for a diversion, and they were not satisfied with that, and therefore a docket had been opened. So we had to explain to them to say, we've got a review process within the NPA, and can we follow this process so that we are able to review the decisions? So it was just things like that, but it was also about communication and making them understand some of our processes within the NPA regarding how we would deal with these type of matters.
I'm looking at the years. The cases referred to here date as far back as 2012 and go up to 2018. So this is not about the integrated team involving the NPA, the PKTT. So this is pre the establishment of that integrated team.
That is correct, Chairperson.
Advocate Harrison, can you just explain, it may not have come across clearly, but when you say dockets were open, were charges actually lodged against individual prosecutors for for their alleged misconduct of these cases?
Chair, there was no need to lodge any proceedings. The first step was, let's have a look at these dockets and determine whether or not they had in fact committed the offenses of defeating. And unfortunately, upon reading the dockets, the decisions made by the prosecutors were found to be justified. And this was a team that sat down and gone through a docket that consisted of a deputy director of public prosecutions, a chief prosecutor, and a senior public prosecutor. So they went through that, and the methodology I've just set it out. So there was no need for any disciplinary action. And once that process had been undertaken, Council, The final decisions and the report, they compiled a report that was submitted to my office. I had a look at the report. I was satisfied. It was quite a detailed report. I was satisfied with their findings. But I did have to report to the Office of the National Director because that had already been brought to attention, I think through one of the meetings, that there had been dockets that were registered against the prosecutors. So she asked for a report, and I gave her the report. Thank you.
Thank you. If we can then leave the minister's letter and go to your directive dated, well, there are two copies of it. The one at 199 is dated 13 June. Can I take you to MK12, page 199?
I'm the counsel.
And that is a directive issued in your name, but if I can then take you to page 248.
I'm the counsel.
And if you go down to page 250, you will see it's a signed copy of the same directive.
Yes, counsel. That is correct.
And what was the date of the signed directive? Well, in fact, maybe I can assist in that regard. Can you go to page 246?
Okay. Yes, counsel. The directive is signed. It would have been signed on that date of. It's dated 21 June 2019, but it's the same directive. It's just that the one on that I attached to General had not been signed 21 June 2019, but it's the same directive. The reason I just changed the dates because I only sent out the directive to everyone on the 21st of June. So I circulated it within the province on 21 June 2019 with what you see on page 246, where I say this is to all the prosecutors, the management especially, kindly find the attached directive in respect of politically related cases for your urgent attention and dissemination to all advocates and prosecutors in your respective units and clusters. And then it's the same directive, just different dates because I didn't just change the date because I was sending it at that time. Thank you.
Thank you. Can we then go to the directive? And I've been working on the copy from page 199, so I'm going to refer you to that one. And first, can you describe the purpose of the directive? What triggered this directive?
Sorry, before that, Mr. Chaskalson, just to make sure we're on the same page, 199, my 199 is a directive dated to the 13th of June. Are you saying it's the same thing as what is in page 248?
It's the unsigned copy of the version or we can shift to the one let's use the signed copy because that is the one that went out. They are the same document though,
yes,
but for the signature and the date. Can you go to page 248, which is the start of the signed directive?
Found it, counsel.
Sorry to move you backwards and forwards, but can you first explain to the Commission why you sent this directive out? What was its purpose?
Commissioners, as you will note, the directive where we're working from, it's actually the same directive. It's just that it was dated the 13th of June and we were still looking at it. But I eventually signed the directive as per the date noted on the directive, which was 21 June. It was then circulated. The reason for this is, as I've indicated, Chairperson, between these dates, as you see, 21 June 2019, and the date of 24 May 2019, or let's say 3 June when I received the correspondence of the minister, there had been a series of meetings regarding this coordination. And with the team and myself that I was working with, we decided, because there had been a previous directive, that is why my one says, this directive replaces Directive 1 of 2018. Clearly, Directive 1 of 2018 was not bearing the fruits that it was intended to bear. And as I indicated, there was already a lot of work. So we needed to revisit Directive 1 and find another way to coordinate the work of the political task team. Therefore, Directive 3 of 2019.
And then can you take the Commission through your directive and just explain the rationale behind each provision of the directive?
Okay. Paragraph 1, this directive replaces Directive 1 of 2018. Then paragraph 2, KwaZulu-Natal has experienced a high level of violence, particularly against persons linked to political parties or perpetrated by persons linked to a political party. And that I literally just took from Directive 1 of 2018. And in order to manage the situation in KwaZulu-Natal, the Honorable President of the Republic of South Africa has convened an inter-ministerial task team comprising of JCPS cluster ministers to look into effective solutions aimed at eradicating the high level of politically linked violence experienced in our division. The inter-ministerial task team will continue to visit KwaZulu-Natal until the situation can be considered to be under control. My office has to provide a comprehensive report to the NDPP on all these matters. That is just really governance. And then paragraph number 4, in addressing the complaints and challenges that have been brought to my attention with regards to 1, only 1 dedicated prosecutor in the province dealing with the matters. 2, prompt decision-making in these matters. 3, reduction of the withdrawals in these matters. 4, prioritization of these matters. And 5, a better collaboration between the chief prosecutors, the assigned deputy directors, and the SAPS task team. So if you look at just 1 to 5, it actually comes from the recommendations, the findings made by Minister Cele in his letter dated 24 May, the recommendations that had been made in that letter, and also the meetings that had taken place that led, these are the challenges that are put in paragraph 4.1, which then I say it has become imperative that this directive be issued in seeking to address the above complaints and challenges.
Can I ask a question about paragraph 2? Are you expressing there your view, or are you simply recording what Minister Cele had said at the time, where you say KwaZulu-Natal experienced a high level of violence, particularly against persons linked to political parties or perpetrated by persons linked to political parties? Were you expressing your own view or simply recording what Minister Cele had said?
My view as well, Chairperson. At that time, it's 2019, and that also came, as I said, from Directive 1 of 2018. At that time, they were experiencing that. But the political cases had not stopped in 2019, so I couldn't leave that out. We were still experiencing a high level of political violence during 2019, and the case numbers will speak for themselves.
So if it was suggested in this commission that political killings in fact stopped in 1994, there were no political killings happening in 2019, what would your answer to that suggestion be?
I would say it's incorrect. There were political killings in the year 2019. Thank you, Chair.
Sorry, Advocate Harrison, I realized from your last answer before the question of the Commissioner that I cut short your discussion of the letter of Minister Cele. You, in relation to your directive and paragraph 4, referred to the findings and recommendations in Minister Cele's letter. Can I ask you to go to page 209? And again, apologies for jumping around. Page 209.
I am there, Council.
And are those the findings and recommendations to which you just referred?
Yes, those are the findings and recommendations.
And maybe if you can just go through those findings and recommendations, because they obviously informed your directive according to your evidence.
Okay. These are found on page 8 of the correspondence from the Minister Cele, dated 24 May 2019. They read as follows. The political related cases, especially murder, are organized in nature with different role players carefully identified, i.e. hitmen, spotters, coordinators, and individuals at the top who are ordering the hits. Number 2, most cases are dependent on Section 204 witnesses that were part of the syndicate, especially when the investigation has to be directed against individuals on top politicians and tenderpreneurs. The involvement of politicians and business people poses a threat of attempts to bribe the criminal justice system personnel. If it falls, then attempts to turn Section 204 against the state. If that fails, if it fails, then attempts to turn Section 204 witness against the state. If that fails, they kill the state witnesses, which results in the case being withdrawn. The lack of dedicated prosecutors to guide and prosecute on allocated cases. The trial-ready cases being postponed for a longer period due to unavailability of dedicated magistrates. The repetitive granting of bail to accused who are already on bail. Then number 10 deals with the recommendations. A dedicated courtroom for the processing of the politically related cases. Dedicated preferable prosecutors and magistrates to deal with these cases. Appointment of a permanent KZN Director of Public Prosecutions. Urgent appointment or utilization of police officials to fulfill the function of the security officers in the Witness Protection Program as prescribed in the Witness Protection Act 112 of 1998, Section 3, subsection 5A3 and Section 6B. Yours faithfully, Minister B.H. Cele, Minister of Police.
Thank you, Advocate. And now if we can go back to your directive and to page 249.
Yes, Council.
And now can you take us through each of the elements of your directive, and at the end of each paragraph, maybe amplify what the purpose was and how you saw that instruction in the directive as helping to address these challenges?
The first one is number 5. All cases involving offenses either perpetrated by a person or persons linked to a political party or against a persons linked to a political party must be considered by the Chief Prosecutor / Delegated Prosecutor before enrollment thereof. In potential High Court matters, the provisions of Circular 3 of 2000 still apply. The Chief Prosecutor / Delegated Prosecutor must ensure that a complete copy of the dockets is forwarded to my office in the most expeditious manner in compliance with the 3-day rule, and the correspondence must indicate politically related cases in the subject line. I'm going to elaborate on this one.
Please do.
Okay. One of the things that the political task team with General Mkwanazi had requested was that we really needed a better coordination system. And if one went back to the history, before I came in, as the acting director in May, there had only been one person that had been assigned to deal with these matters. And I think that is expressed very well in my correspondence of 10 June 2025. So when they asked for a coordination of these cases, we then responded to say, okay, because it's only one person, and the matters are emanating from the different clusters, from the Durban cluster, to Zuma cluster, and everywhere. We decided that the chief prosecutors must be the first line of contact to deal with these matters. As a result thereof, it was decided that due to the, as I said, we were going through a time of austerity measures. We were not recruiting. So we decided that the chief prosecutors, because the matters are within their space, they must be the first point of contact, and hence paragraph 5 of that correspondence. So that is what it was addressing, a coordination. Paragraph 6, maybe just to also just to take it a little bit further in regards to the docket copies to my office, it was also, remember that towards the bottom, I do say that the coordinator will be Advocate Slepe. It was for us, because when a matter is brought into our office, we open files. Therefore, this matter, every matter that was going to be coming in should be registered, and it must be within 3 days, so that we are also able to monitor the progress of all these matters. So in the clusters, they'll have their database, but I will also have a database operating from my office regarding these political matters. Then the chief prosecutor delegated must interview the witnesses in these cases prior to the enrollment of these matters, especially in cases involving accomplice witnesses and single witnesses. Legible consultation notes must be filed in the B section of the docket. So before you enroll any of these matters, we requested that there must be a consultation with the witnesses, and this was to deal with the matter of cases being withdrawn. So one of the complaints is that matters are enrolled and then cases are withdrawn. But this was as a result of you only really consult with the witness when you're ready to go for trial. So to try and eradicate that with these type of matters, we then requested that before you even enroll, speak to your witnesses. That was to deal with the withdrawal issues that have been raised, so we try and reduce them. Then in respect of pending cases, the chief prosecutor or delegated prosecutor must interview the witnesses before a decision is made to transfer the matter to the regional or high courts. Legible consultation notes must be filed in the B section of the docket. This was to deal with two issues. The one issue is the withdrawal issue, and the other issue is the delay of the matter being placed on the roll for trial. So it was two-pronged to deal with those two. In that regard, so we also don't have withdrawal of these matters. And then the decision to decline to prosecute a person and rather use such a person as an accomplice witness in terms of Section 204 of the Criminal Procedure Act 51 of 1977 must be made in consultation with the chief prosecutor and or DDPP in potential high court cases. That would be the Deputy Director of Public Prosecutions. The provisions of Section 204 should only be used in exceptional circumstances where it is in the interest of justice to do so. See in this regard Section D, Part 4 of the NPA Policy Directives, Section 204 witnesses. So this was to now deal with the issues that had been raised regarding the Section 204 witnesses, where we were just saying before you decide on having a witness, be a Section 204 witness, there are certain things that the Prosecution Policy Directive has put into place as safeguards, and they must have regard to those. Those are contained in the policy directives. And then the chief prosecutors and deputy directors of public prosecutions must ensure that a database of these politically related cases is maintained for the cluster or units, and that by the 10th of each month, one update for the whole cluster or units or offices is forwarded to the Strategy and Operations Office, attention of Mr. Sunil Prithipaul and Ms. Imelda Mngomezulu. So again, this was just for the governance issue so that we maintain the progress and we can monitor these cases as they're under courts. No politically related case may be withdrawn without detailed and cogent written notes and reasons in the C section of the docket or DPP office file. Again, this was so that we monitor the withdrawals and the reasons that were provided for the cases that prosecutors. And then the last one, Advocate Slipper remains the coordinator for these matters. And where there is a doubt in regards to a decision, he can be contacted for assistance. That was my directive, Commissioners.
And if we then go to Annexure C, it appears at page 210. And do you recognize this document?
I recognize it, Council.
Can I take you to page 252, the foot of page 252, and will you confirm that that is how you received the document? At the bottom of page 252.
Yes, Chairperson, that is how I received it.
And would you just read into the record the date of that covering email?
This is dated the 27th of August, 2019. It was addressed to myself at that time, being Elaine Zungu. It is from Brigadier Dumsane Kumalo. This is now General Kumalo. And reports to the NDPP and National Commissioner.
And can you describe what this document, Annexure C, that starts at page 210 is?
Okay, this was a progress report. There had been a meeting on the 23rd of August, 2019, and this was a progress report regarding the cases for investigation and prosecution. And if I remember, it's dated 23 August 2019. This had been presented at the meeting of 23 August 2019. We had then requested for copies of these so that I could then transmit to the office of the Advocate Batoy.
Thank you. Can I ask you to go down to page 218, where matters of concern are listed? Sorry, before you get to page 218, who did the presentation?
During the meetings, General Kumalo would do the presentation.
Thank you. And then if you go down to 218.
I'm there, Council.
And a list of matters of concern appears on page 218. Is there anything you would comment on in relation to this list?
Council, there's nothing much of concern except for the fact that it was just being reiterated, because if you read the paragraph above the matters, it's just that it's just to highlight that those matters were directed against individuals on top, like politicians and entrepreneurs who are mostly not directly involved in the commission. But the fact was there were 204 witnesses that were involved in those matters. That were part of the conspiracy or planning. So I think the concern is when you read that, it is these matters are like our 204 witnesses. Remember the challenge that had been raised. But in these matters, we've got 204 witnesses.
Thank you. And then there are on page... there are more matters of concern over the page on 219. Can you look at 219, and is there anything you want to comment in relation to those matters of concern raised at the in the presentation by General Kumalo?
Thank you, Council. Again, remember this is a meeting on the 23rd of August, And again, the issue of lack of dedicated prosecutors has contributed to the backlog of cases. So again, there was the issue of the coordination that was coming out again, despite the directive of 3 of 2019, there were still concerns raised regarding the coordination, the delayed decisions whether to prosecute or not, also negatively affecting the turnaround time and finalization of investigation of these cases, the questionable decisions to withdraw the cases or charges against some individuals without valid reason, endorsement, and queries in the docket, the delaying of trial of an accused is pleading guilty, which leads to accused persons to be influenced otherwise and change their plea of guilty. The trial-ready cases being postponed for a longer period due to the unavailability of dedicated prosecutors and magistrates, reluctance to prosecute on single witness cases, dying declaration, child witness, and circumstantial evidence, the repetitive granting of bail to accused who are already on bail.
Do you have comments on these matters of concern raised by General Khumalo or Brigadier Khumalo at the time?
You know, when one looks at these concerns or matters of concerns as they've been labeled on page 219, you can see it. They were clearly coming from the part of the task team saying these are the concerns that we've got. These are the concerns that we have regarding these matters, and we needed to obviously provide. It was coordination. You know, when you read all of this, it's about coordination that was in. That was really a problem, because if you look at these concerns, and if one goes back to the different meetings that we had to during case progress or any meetings, these are the similar concerns that have been raised. Then you go back to the letter of 24 May 2019. Again, these are the concerns that are justiciable or not.